Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we explore the world of innovation, creativity, and intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from inventors, entrepreneurs, and experts in the field. Now, before we get started, I want to make it clear that while I am an attorney and a patent attorney, the information I provide on this podcast is for educational and informational purposes only. I'm not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. And with that disclaimer out of the way, let's dive into the world of patents, intellectual property, and innovation. Join me on this journey as we explore the power of inspiration and how to turn your ideas into reality. We're on the third episode of this first week. From IP confusion to IP clarity, understanding what inspirations can and cannot be protected. And in this episode, we are covering when is your inspiration protected, to learn about the laws safeguarding intellectual property rights. One of the myths I've heard a number of times is what I call the patent post office myth. So I've heard of inventors who will take their invention, they'll write it down, and they'll mail it to themselves through the post office so that it has a stamp on it of when it was mailed to prove that they were the first one to invent it. And then they keep that envelope sealed and they say, well, I've protected my invention. And sometimes they even refer to, I've registered it, or I have a post office patent. So all of those don't work. Before 2013, and this has changed now since 2013, the US patent law said the first person to invent and files a patent application will be entitled to a patent application. Now, there were some caveats in there. You had to not just invent it, put it on a shelf and do nothing with it. You had to show you kept working on it. But if you worked on it, you invented it, you worked on it for 3 years, and then you filed a patent application, if someone else invented it and after you, but filed a patent application before you, you would be the one in a contest between the two of you that would win and would get the patent. This was actually the case for the laser. It was a 20-year battle in the patent office to determine who got the patent, the professor or the student. They both claimed they were the one to invent the laser. It took 20 years to resolve it. And then they figured out who invented it first. So that's all changed. And so proving you invented it first no longer helps. And even then, you still had to file a patent application. If you didn't file a patent application, you've got nothing. Now it is first to file. So if two inventors invent the same thing independently, and they both go to the patent office and file a patent, the first one there gets the patent. It's simplified, and there are pluses and minuses on both sides, but that is the new system. And that has been the system in most of the other countries around the world. So we're actually more similar to other countries. And there was a lot of thought and effort put into this, and they decided that this is the way it's going to be. Whether or not you like it, this is the way it is. It's a first to file system. If you don't file a patent and somebody files before you, they get the rights. So now that you know you have to be the first person to file a patent application, what do you need to do to get those property rights in your invention through a patent? And you need to know what actions especially can prevent you from getting intellectual property rights so that you can take the right steps in the right order to maximize the value of your property. So the first thing you want to know is that you want to keep your invention secret. Do not offer the invention for sale. before you file a patent application. So that's for patents. With patents, there is considered a grace period of 1 year from if you publish or put your patent or put your invention on sale, even if you don't sell it. If you have a offer it for sale, that starts a 1-year clock. Now, the challenge with the changes in the law is, even though they still have that in there, the challenge is if somebody else publishes before you file a patent application, that publication will likely stop you from getting a patent. And so even though there's a grace period, that grace period can be swept out from under you in a moment's notice with somebody else publishing. Before, in the old system, you could submit proof that you invented before that publication date, and they would ignore that publication. Now that doesn't exist. You need to, and that's why for best protection, you need to talk to your patent attorney and discuss filing a patent application before there's any public disclosure. Now, for a trademark, you want to, for your brands, you want to file a trademark application as soon as possible. And there's a process where you can file your trademark application before you even use it. And that is really the best protection you can get. There's a very small extra cost, but it gives you a huge advantage. So there's been many cases where 2 companies have started using a brand that's very similar or even identical at the same time. And if neither of them files a trademark application initially, and then they both file a trademark application later, they'll have a contest where they'll have a court. Well, it's the Trademark Trial and Appeal Board, but it's a court that decides based on evidence that's presented who was the first one to actually start using the brand in commerce, to actually use it in a transaction, actual sale. And whoever can prove they were the first one to use it is going to be the one who's going to get the rights to that. Now, you can shortcut that process. If you file a trademark application before you use it, they treat your filing date as the date you used it, even though you haven't used it yet. So you can beat somebody to the trademark office. And so trademarks, like patents, there's a contest of who is first. And it's first to use. But if you have a contest between who's first to use, that's going to cost a lot of money. It's a litigation process where each side presents evidence, makes arguments, argues why the other person's evidence is no good and why theirs is better. That takes a lot of time and money. But if you just file your trademark application as soon as you've made a decision that you're going to use it, you get those first rights. If you've just done the research, then, and I encourage you to do research, is anybody using this first? And if nobody's using it, as far as your research can tell, and you file that right then, or really shortly after that, you've got a very clear path. Now with patents, when you research them, patents are not published for 18 months. And if the inventor elects, it won't be published until it's actually granted. So a patent can be hidden in the patent office for 18 months or even years. And you can't find it, you can't research it. But with a trademark, within a day of filing a trademark application, that application is public. The next thing for your creative original content, and we talked about that in the first 2 podcasts, and look at what is there something that you're selling? If you're selling your original content, I encourage you to file a trademark application or a copyright application. Now, trademark and copyright, you can have rights and you can sue. Well, you can claim rights based on your creation or use. With a trademark, if you're first to use, you can actually still go to court and sue somebody for that. But you have so much stronger rights if you actually file a trademark application and get it registered. With a copyright, you actually need to have that copyright registration to be able to sue somebody. And so you'll want to have that for something that's valuable, something that is worth suing over. You'll want to file a copyright application. You have rights, and you can put that circle C on anything that is your original creative content, even an email. If it's your own creative content, then you can put circle C, and you'll see the copyright notice. Now, for trade secrets, you don't file anything, but you need to have agreements, contracts with anybody who knows your secret, and make sure it's only on a need-to-know basis. Have contracts that are clear that they can't use it, they can't compete with you, they can't disclose it unless they're working with you. And that's very important for contractors. Now, one of the other things with contractors is they might own the creative content that you're paying them for, even though you're paying them, unless you have an agreement with them saying that you own it. So what is it you need to do? So for any inventions, review the first publication or on sale date to see whether it's in the past or the future, and make sure you have filed a patent within that 1 year or before you have before you even publish or put it on sale. Conduct your research, like I said, and find out if others are using your brands. And for copyrights, file a copyright application within the first 90 days of publication for anything that you're going to sell. Now, I encourage you to take 5 minutes to write down what intellectual property in your business needs protection to achieve your goals. Thank you for joining me for the Leveraging Inspiration, the Inspired Patent Podcast. I'm Wayne Carroll, and I'll see you next time.